You're wondering about the 1 to 4 family contract in Texas and you're a real estate agent and you can't serve your client to the fullest? Well, join me on this training and I'll help you out with everything you need to know. Alrighty, so let's jump into paragraphs 8 through 17. I'm going to knock these all out because they're kind of short paragraphs and they're very decisive and right to the point about things. And it's probably not the other ones. There's a lot of little things over there that kind of people don't understand, and we discuss a lot in my office. So I want to go through those a little bit more detailed. So let's jump into this. Paragraph 8, alpha. Simply put, hey, look, if you're a party to the contract and you're a licensed real estate agent, then you have to disclose to the other party. That's what it basically says. It doesn't matter how it's, twisted or whatever. You have to disclose if you're a licensed agent in the state of Texas to the other party. It also sits there and says, okay, if you're related to the party or to a party, that you must disclose that you're related to them. And when they mean in terms of related, we're talking about, spouse, parent, your child, brothers and sisters, immediate family must disclose that they're, representing the party and they are your immediate family. You must disclose that, right? It also says in 8B that as of right now, broker fees are contained in a separate written agreement as we speak today on October 13th, 2024. Anticipate that changing soon. Section 9, simply put, hey, look, we're looking at what the closing date is going to be. It says on or before. And whatever date you put in there, it's supposed to close. Now, I think I'm going to piss off some lenders here, but I'm just going to put it to you straight as agents. This date you get from lenders, you should get from lenders. I recommend that you get this from lenders. Of course, if you got somebody giving a loan. However, I've just seen in my experience when these dates are not met, I would say 80% of the time it's because some lender was not on their JOB. And they've gotten documents, or they'll say, hey, they couldn't get the documents for the buyer and they didn't give them stuff or whatever the case would be. But oftentimes good lenders, they're so proactive. They're talking to listing agents and buyer's agent. You don't have to chase them down, and they're so out in front of things. And you're just amazed by what they do and how they do it and when they do it, and get everybody on board quickly. Once you've been through that type of lender, and then you get the other type of lender that you got to chase down, you got to harass, and they don't talk to you. There's no communication, and they start dodging you. As soon as lender starts dodging you, I know it's going to be a nightmare. Something's wrong. Something's off. All right. So that's just my little spill there. I know I'm going to piss some lenders off, but that's just the way I feel. Don't care. All right. So let's go into this. So that's pretty much about section 9, just the date you're going to close on or whatever. If you're not going to close on that date and it's going to be extended, you have to go get an amendment, amend the contract to the new closing date. You don't put it here. You don't scratch it out and change it here. You go do an amendment and you change the closing date. And that's what you do. Okay. Let's go into section 10. Section 10, possession. Pretty simple. Usually on the time that closed end funds, there's two different things going on. Closing is one thing and funding is another thing. That's when a buyer can take possession. The other option is the buyer can take possession based on what a temporary lease says. The lease can be on a Texas real estate form, or it can be on any form that they really have in place at that time, and it can be used and whatnot for that. So if a buyer could take possession before the closing date, or a seller could do a temporary lease after the fact, and the buyer not take possession until that lease is done. So it can work several different ways. It does have in their bold print, says consult with insurance agents prior to change of ownership and possession, because insurance coverages may not cover certain things. So you make sure you do that with your buyers and your sellers to make sure they're abreast of what their insurance is required. 10B talks about smart devices. Smart devices is huge right now because we got all this stuff that is houses ran by smart devices. And when people leave, I had a situation where the refrigerator just like talked and, had to tell you if the milk was spoiled and all this other stuff. And essentially, um, we were left, my buyer was left without the um, uh, reset and controls for it and all this other stuff. And it took a while to get it. And it was just a nightmare. And my buyer was really upset. So, in that sense, all smart devices, all access codes, usernames, passwords are supposed to be turned over, or they're supposed to be reset to the factory settings so someone can come in there and do it themselves. And they're all those access codes and everything like that is supposed to be removed from people's, at least the sellers, cell phones and their devices and stuff like that. So there's no issue that you still have access to certain things that's not in the house, that's in the house, and you sold it and you're messing with the new buyer, right? So that's what it's all about. Now let's go into special provisions. Um, Special provisions is one of those things that's always, there's like a taboo. Don't ever write in special provisions. And I always heard that when I was an agent, and then when I became a broker, I kind of understood it. And as it becoming a designated broker, I kind of I came to this time where it's like we really don't really want to mess around with that. And I became a designated broker in 2020 when people were doing all types of crazy things with special provisions. So we learned a lot about it. Simply put, you can write in special provisions. You can make factual statements according to the contract, but you don't want to be perceived as practicing law. So that's the reason there's so much guidance on not to use it. But if you had to use it, as long as you was saying factual information and not changing or deleting or adding to the contract, then it's okay. I would always caution on the side of, hey, talk to your broker and see what they allow. But if the contract does allow you to say certain things, I gave some examples of things I've seen that I think is okay. Uh, Seller to pay off solar panels at closing. All right, it, if they're paying it off at closing, I mean that the fixture lease in section 4 doesn't fit, right? But you want to annotate it. You want to have some type of solid um, in writing process, and you can just say that. I gave another example here about the survey. I've seen where survey is going to be split in half. Well, survey and buyer agree to split cost of survey 50-50 at closing. That's just a factual statement. It doesn't change any. It doesn't, and it's not really outlined in the contract, but it does have the effect of the contract. So that's something that you could, is allowable. Again, I side of the caution. Talk to your brokers in terms of what you should and shouldn't put in that actual statement there. All right, let's keep on going. Uh, Section 12, settlement and other expenses. Simply put, if a seller is helping or assisting the buyer with buyer expenses, this is the section where you would annotate that at. In this case, the seller was helping with $6,150 to be applied to the buyer's expenses. And that's pretty much that. This is all this section really does. Section 13, um, it outlines prorations and how it affects for the current tax year, and it also tells you in this section, if taxes are not paid at or prior to closing, buyers shall pay taxes for that current year. It's telling you in the contract. Casualty loss. Simply put on that one, if something happens while you're in the contract and a fire or some type of catastrophic loss to the property, the seller can restore. They have until the closing date to restore, and if they don't restore it by the closing date, the buyer can terminate and get their earnest money back. Okay, that's section 14. Section 15. Section 15. If parties default, this is the paragraph where it falls in this category about what the buyer and seller can do if either party defaults on this contract. And it goes in details about um, that. Now, it also specifies, if you see this, it says, okay, if buyer fails to comply with the contract, buyer will be a default. And seller may enforce specific performance, seek such other relief as may be provided by law or both. All right, can do both. B, terminate the contract and receive earnest money and liquidated damages, thereby releasing both parties from the contract. Now, I'm going to explain this because a lot of times people don't get and understand this. So, whenever the seller, if you will, collects the earnest money, it means that both parties are released from the contract. All right. So no other damages could be sought after and things of that nature. If a seller truly wanted to go after a buyer for whatever reason because they didn't close and all this other stuff, it's probably in the best interest of the seller to release that earnest money back to the buyer, then seek legal counsel and go after the buyer in that way. But as soon as the seller accepts the earnest money, they've released that buyer legally from any non-performance of the contract. So make sure you understand that and make sure you explain that to your buyers and make sure you explain it to your sellers. That's what it's basically saying. In paragraph 16, basically talking about, hey, if it escalates, we're trying to do some form of mediation first, and if mediation doesn't work, then section 17, it talks about attorney fees, and it says a buyer, seller, listing broker, or other broker or escrow agent who prevails in a legal proceeding related to this contract is entitled to recover reasonable attorney fees and all costs of such proceedings. So that's in the court of law, and simply put that way. All right. So we have those sections. I'm going to end it there. I'm going to pick up on section 18 on my next part, and we'll finish this thing out and hope you got something from this.